My lords, my lady, on the main issue of whether or not the judge erred in making the conclusion that he made at paragraph 297, as you will have seen from my skeleton argument, my case really distills to four straightforward propositions, which it might be helpful if I just set out at the outset. The first is that this appeal is concerned with a straightforward factual conclusion made by the judge on the evidence given at trial. Namely, even if the bradycardia had been monitored earlier, Miss Nix would have intervened at the same time. It is not concerned with an error of law, and the judge made no bolum belitho error. Secondly, that factual conclusion was one which the judge carefully considered and analysed. There were gaps in the evidence for reasons that I've explained, but the judge had this factual issue very much in mind, notwithstanding those gaps. Thirdly, there is a very high threshold applied.
Sorry, can you
I'm
just...
so sorry,
no,
my lady.
It's all right, Mr. Charlton. Yes, sorry. Point 3, yeah.
Point 3, there is a very high threshold applied to interfering on appeal with considered factual conclusions of this nature made by the trial judge. And fourthly, the conclusion that the trial judge reached was one that was reasonably open to him on the evidence, and the stringent test for displacing it has not been met. And can I briefly develop those four submissions, my lords, my lady, in that order? First of all, the judge's conclusion was a straightforward factual one, no error of law. And in my submission, the bolum belitho analysis advanced by my friend is an attempt to dress up a straightforward issue of fact as an error of law. Everyone at trial was well aware, as my lords, my lady will have seen, that the essential question on factual causation is what would have happened as a matter of fact if CTG monitoring had picked up a bradycardia on the labour ward sometime earlier than Miss Nix heard it. And the defendant's case on that question was simple and purely factual. And it is summarised in our written closing submissions in the supplementary bundle at page 8, which is probably the most efficient way of dealing with it. At paragraphs 16 to 19, the essential case that was being advanced for the defendants on that factual causation issue was that if the claimant's mother had been on the labour ward with a CTG running significantly earlier than 1750, she would have been under the care of the midwives in her delivery room. The midwives would have picked up the bradycardia, heard the bradycardia on the CTG, but as all the experts accepted, midwives would not immediately recognise or diagnose a bradycardia until it had been running for some time, because it might otherwise just be a brief drop in the fetal heart rate. Once they had recognised it, after a period of time, they would then summon obstetric assistance. That was the agreed evidence, and that obstetric assistance would, in the ordinary events, take some time to arrive. In my case, the defendant's case, simply put, in response to all of that, was, well, in the event, Mrs. Nick's intervention intervened in that period. And so no time would have been saved, because before the midwives had got to the point of identifying the bradycardia and summoning obstetric assistance, Mrs. Nicks was already there. That was the factual case that was advanced to the judge on factual causation by the defendant. And these were not Bolam points. These were simply factual but for submissions. Now, that analysis, that essential analysis, was reflected in the judge's judgment at paragraph 296, which I wonder if I could briefly invite the court to turn up.
I think we know it by heart.
I'm sure you do, my lord. You'll note and recall, my lord, in that case, the use of the words "most probably" by the judge in that paragraph. I find as a fact that when the CTG became bradycardic, the midwife would most probably have called for obstetric assistance within a number of minutes. And as a result of that most probable finding, he then goes on to find at 297 that things wouldn't have happened any quicker than they in fact did, because that was the period within which, as a matter of fact, Miss Nicks arrived. And so this was a debate undertaken purely on a factual basis, not what a non-negligent midwife would have done, or how long a non-negligent obstetrician would have taken to arrive. Simply that by the time the midwives identified the bradycardia, Miss Nicks was already there. Now, insofar as it's necessary for me to do so in light of that analysis, I do also observe that the learned judge, and this I don't understand to be disputed, directed himself correctly on Bolam and Bolitho at paragraphs 303 and in particular 306, where he quotes the passage of Bolitho on which my learned friend now relies, 306, about the relevant question being, what would that actual doctor have done in the but-for scenario? So the submission must be by my learned friend that despite directing himself correctly on the question, he nonetheless failed to apply his own direction when he came to analyse the evidence at 296, but as I've already submitted, there is no evidence for that at all. And so in my submission, my learned friend is wrong to submit, as she does at paragraph 1.7 of her skeleton and as she's submitted this morning, that he applied a Bolam negligence analysis to what would have happened had a CTG been running earlier. He doesn't mention self-evidently, I won't weary my lords, my lady, by going back to it yet again. He doesn't mention negligence, breach of duty, Bolam, anything like it in 296, 297, or indeed in the entire factual causation section of his judgment. And in my submission, it's quite clear that he did not make that error.
Well, just in respect of that, Mr. Sheldon, I understand what you're saying in respect of 296. He would most probably have called, midwife called for obstetric assistance with 1 or 2 minutes, max 3. Although he is finding that as a fact, that relates to evidence that was given by the experts as to what would have been reasonable.
Well, no, my lady, in my submission, it was given by it was evidence given by the experts as to what is likely to have happened as a matter of fact, because you would not, as a midwife, as a matter of fact, diagnose bradycardia until you'd seen a low fetal heart rate for a period of minutes.
Can we just go back to, I know we went to it before the short adjournment, can you just refer me back to that paragraph? That earlier paragraph, where it was the obstetric evidence, wasn't it?
Yes, my lady. The relevant paragraphs for these purposes are, first of all, 190. This is a reference in the obstetric evidence, and you'll see at paragraph 190, both obstetricians agreed that once bradycardia was appearing on the trace, it would take probably only 3 minutes for that to be properly identified, as distinct from a deceleration. So they weren't saying it would take a non-negligent midwife 3 minutes. They were just saying, as a matter of fact, it's going to take a midwife a period of time to realise that this isn't
it was what they would do rather than what they should do.
Exactly so. And similarly, at page page 160, paragraph 208, he quotes some timings that were put to the claimant's obstetrician and agreed with. Bradycardia, this was on a hypothetical scenario. Bradycardia would have started at 1746. It would have taken, pick up my lord's terminology, it would have taken 3 minutes for the midwife to recognise the bradycardia and call the obstetrician, 1749. It would have taken 3 to 5 minutes for the obstetrician to arrive. So no one was falling into the Bolan-Bolitho error that my learned friend has identified. We all understood, experts, those of us asking the questions, and most importantly, the judge, that what we were dealing here was fact.
Or counterfact.
Counterfact, exactly. And that is the way. I won't take the call back to it. But in my closing submissions at Supplementary Bundle 8, that's precisely the way it was analysed. No reference to Bolan. The references to the expert evidence which I cited were those parts of the expert evidence where the experts were invited to tell us what, in the ordinary run of a busy maternity unit, would likely happen. So no error of law that infects this critical factual conclusion. And that's vitally important, my lords, my lady, because it makes the starting point of this analysis that we are dealing with a straight down the line factual conclusion made by the trial judge. And that obviously has implications when we come on to the test in just a moment. Second submission I make is that was a factual finding that the judge made on careful consideration of the evidence. And I'm going to take the court, if I may, just to a small handful of references in the closing submissions, not for the purposes of unpicking the merits of what we were both saying to the judge or what the judge was saying back to us, but simply to illustrate that he had this point very clearly in mind and was directing his mind to it carefully. Now, can I, first of all, the first reference is in my closing submissions at Supplementary Bundle, page 201. Should say, my lords, my lady, I adopt without repetition the bit of my written closing which flagged this issue up that I've already taken you to. So if everyone knew we were going to be talking about this issue at the end of the evidence. And by this issue, I mean whether Miss Nix might have intervened any quicker than she did. And at 201, at line 14, I make a submission a few minutes earlier that in fact was heard fortuitously by Miss Nix at 1750, as she happened to be outside the door at that specific point, would not in fact have resulted in earlier delivery. course, I'll come on to explain why I say that. And I say again, my lord, I'm not inviting the court to accept or reject my submission, just making clear that I made it. And then the learned judge says, well, you don't know where Miss Nix is 3 minutes earlier. We were talking about 3 minutes at that stage, but the point is we don't know where she was before she intervened. I respond exactly. And then over the page, 202, she might have been anywhere. We had no evidence on it. She could have been finishing an emergency operation elsewhere. It could therefore have been Mr. Heath. We just don't know. And then a little further down, we're crystal ball gazing. We don't know where all the moving parts are. And then to similar effect, at page 217, again in my closing submissions, the judge returns to it. This isn't, I should observe, my lady, a comprehensive list of references. They're in my skeleton argument, but these are the key ones. Mr. Justice Ritchie at line 5, dealing with the counterfactual. It was a fact that Miss Nix walked past the delivery suite room in which the mother was situated and was checking the notes ready to go in for her ward round to see the mother at 17:50. Yes. Nobody has disputed that. No. So if the Brady had started at 17:47 or 17:48, what you say is that events would have been the same. Yes. She would have walked in when she walked in, yes, and events would have been the same, and the but-for collapses. Now, this is my submission, exchange with the judge. But the conclusion that you see reflected at 297 is the judge's acceptance. In my respectful submission, he was entitled to accept my analysis of factual causation on the evidence. Finally, for this set of references, 219 at the bottom. Line 18, again, my submission, the whole bringing the bradycardia forward to save time on delivery is founded on a fallacy that Miss Nix, or the assumption that Miss Nix, is standing outside the door the instant the bradycardia starts. Mr. Justice Ritchie says, well, that's the problem with the but-for. Sometimes but-for is taken on expert evidence on the likely time within the reasonable parameters. So he's identifying that sometimes you might do what my learned friend has accused him of doing here, often based on expert experience, but sometimes based on guidance, 30 minutes for a Cat 1, quicker for a Cat 1 superfast. But at other times, he says, the but-for is put on, well, that's what happened, and therefore that's what would have happened if we bring things forward. How am I supposed to decide between those two when I don't actually know what happened is what would have happened, because the moving parts would have been in a different place? And then I submit, well, it's easy to resolve that difficulty, because my lord just asked himself the question of whether or not the claimants have proved their case. And I pose the question that I pose at line 14. Now again, the merits of that submission are as they are, but this was clearly at the forefront of the judge's mind. And it remained at the forefront of his mind when we come to my learned friend's closing submissions. First of all, at page, well, I took you to 222 and 223 earlier, so I won't go back to that, my lord. 226 is the next reference. My learned friend Miss Gumbel says at line 16, going back to this same issue, if she'd been standing outside and a normal CTG had started a bradycardia, she would have gone in and looked at it. Then the judge says, I was consultant on call, he reads out her witness statement, or the relevant parts of her witness statement. Ward round at 17:50, I was outside. She doesn't say at 17:46, I was outside, but she said they were all approximate timings. And we know that she wrote, 17:50 comes, that's the time she wrote her note of the ward round. We know that she wrote that much of her note. She went straight in. And she did the scan at 17:54. And then finally, 227, over onto 228. Perhaps I could just invite my lords, my lady, to cast their eye down the rest of 227 and up to line 3 on 228. Now again, not for the merits of the submission, but to illustrate that this was a key issue that was being carefully considered by the judge. Now, any stage during this trial, and at any stage during closing submissions, my learned friend could have pointed the judge to evidence that compelled the conclusion that Miss Nix was standing static outside the room for 1 minute. I accept her point on timing, she couldn't have known the timings, but was standing static outside the room for 1 minute, during which she could have intervened if only a CTG had been running. She could have shown him evidence, if there were any, that compelled that conclusion, but she didn't. And so he was not compelled to reach it, is my simple submission. So it's a factual issue that the judge carefully considered, and that means, in my submission, that we are squarely within the principles that have been identified repeatedly by this court for interfering with findings of fact made by the trial judge who's heard all the evidence. And I wonder if I could just turn up one authority for these purposes, which in my submission provides a useful summary of all of the principles in one place. And that's the Stachelin decision, which is in the authorities bundle at tab 12. That starts at page 253. I'm going to take this, if I may, my lords, my lady, quite quickly, because I know how familiar the court is with these cases. Stachelin is a convenient one to look at, but there have been a number since which reiterate the same principles. Volpe and Volpe is a well-known one. My Lord Justice Jackson, remember that these principles were again set out in U3 recently, but this is a convenient place to see them all together. It's a case about the payment of commission for the sale of a Gauguin painting, so about as far away on the facts as we could get, and I don't think I need to trouble you with the background. The relevant passages are at paragraphs 29 and following at page 260 under the heading Appeals on Fact. Lord Justice Lewison starts by repeating what he has said before at Phage, and I could perhaps just invite my lords, my lady, briefly to scan paragraphs 29, 30, 31, and 32.
Yes.
And then I'm picking it up, if I may, at paragraph 33. Lord Justice Lewison cites a recent decision of the Supreme Court in Perry, which provide the helpful summary of those foregoing principles in relation to challenge findings of fact. Was the trial judge's finding one that no reasonable judge could have reached? You'll see how that principle was applied as a matter of fact in paragraph 34 of Stachelin. And we do have, my lords, my lady, we do have Perry in the bundle. It's the next authority, even though it was decided just before Stachelin. And the relevant paragraphs are 49 to 52. And I think the 49 to 53 are really a recitation of the same principles that you've just seen in Stachelin, but 52 is potentially helpful by way of further exposition. Because the Supreme Court provides a summary of those principles at 52. This is page 301 of the authorities bundle. they may be summarised as requiring a conclusion either that there was no evidence to support a challenge finding of fact, or rather that the trial judge's finding was one that no reasonable judge could have reached. Now, Perry was a case about vibration white finger, and again, I don't imagine that the facts are particularly interesting. Those principles in my submission are of universal application. They have been repeatedly restated by the highest courts, and they apply squarely here. So to my fourth submission, my lady, which is in light of all of that, the question for the court is, was the conclusion reached in the first sentence of 297 a conclusion that no one could have reached on the evidence that was before him? And in my submission, it was plainly a reasonable conclusion that the judge could have reached. And there was nothing in the evidence that compelled the conclusion that there was a 1 minute period of potential action on the part of Miss Nix that was lost by the defendant's negligence. There was no evidence to compel that conclusion. In fact, I'd go further, not that I need to in my submission, that there was no evidence upon which he could realistically have reached that conclusion. Can I briefly take you to the key parts of the evidence which in my submission make that good? The first is the contemporaneous medical notes, which we looked at briefly before lunch, and which I won't, unless it would assist the court, go back to for these purposes. They're at pages 90 to 91. But the crucial point for these purposes was that they told a very unclear picture, or they painted a very unclear picture of precisely who was where and when. Because whilst there was evidence on at least some of the approximate timings in the witness statements that Miss Nix was outside the room at 1750 talking to Miss Bond, Miss Bond wrote a contemporaneous note timed at 1751 saying she was introducing herself to the patient.
Well, I'm looking at 1751, introductions made, patient in a lot of pain, Entonox provided. The internal evidence is there to show that the figure of 1751 is likely to have been the time when the note was made, not when the time that introductions were being made, pain acknowledged and drugs prescribed. It's most likely one would have thought to have been an after the event note, but
well, my lord,
and it takes a certain amount of time to do the things that it describes, let alone write it down.
I accept that, my lord, but we do have the preceding note as well, which is 1750 transferred, handed over to midwife Bond.
Yeah.
1751 midwife Bond writes introductions made. 1753 over the page, Miss Bond writes CTG.
Yes, I'm just saying that one has to be careful that one doesn't treat the time when a note is made as being the time that the thing described in the note has happened. That's all.
I accept that entirely, my lord. But that really only goes to underscore the point that I'm seeking to make, which is that the contemporaneous notes fall a very, very long way short of establishing what my learned friend now seeks to establish in order to impugn the judge's findings, namely that there was a minute of potential action on the part of Miss Nix. Because as the judge put it, working out where all the moving parts were, who was where, precisely when, with what specific choreography.
So what it comes down to is, I mean, if we might call it the lost minute,
Yes, ma'am.
that this is the case that's being made now, and that is the lone survivor of a previous series of allegations that were made about on this particular issue. So your general point is that it's asking too much to require the judgment to have extinguished the lost minute when that wasn't a case that was squarely put?
My lord, I'm putting it, if I may, slightly differently to
Yes,
that.
please.
I'm posing the question of whether, given the principles I've identified, the evidential picture was such that the judge was compelled to find the lost minute.
Yes, well, it would be
That
on
was
the way it's put now is it's on the basis of his own findings. He was compelled to find the lost minute.
Yes, findings made. I would respectfully submit en passant in a factual aspect, a factual part of his judgment that was not expressly directed to factual causation, and in circumstances where he wouldn't have no idea when he made those, when he identified those timings of paragraph 141, that this minute was going to, on this minute, the whole case was going to hang.
Well, I grasp that point, but at 297, where he is finding facts for the purpose of causation, I find as a fact that Miss Nix was outside Claimant's mother's room at 17:50. That's a fact. He's found. That's where she was.
Yes. Yes.
That's an immovable starting point on his findings.
Yes. And what my learned friend is seeking to do, is to interpose there, in that part of the judgment, an additional finding, which is, I also find that she was standing out there for a minute before she went in to intervene in the delivery of the baby. And that, had the CTG been running in that minute, she would have intervened earlier. That is what the claimant is now seeking to read in to paragraph 297. And in my simple submission is, the judge was not obliged to find that. He couldn't have got that from the notes, as I've just sought to submit. Nor could he have got that, let alone been compelled to find it, from Miss Nix's own evidence. And can I briefly turn up Miss Nix's evidence?
The difficulty is, isn't it, that Miss Nix, on any scenario, is standing outside. She has no particular reason to be aware of the precise time she's standing outside. The first trigger is when she hears the bradycardia.
Yes, my lady.
And so everyone is going about what might be called their normal activities. And timing becomes critical once they realise something is going wrong.
Yes. And all this, with respect, would have needed, if this case had been before the judge, would have been for Miss Nix to be asked by anybody, prior to that intervention, when you went into the room, were you standing in exactly the same place for about a minute or so beforehand? Or did you arrive outside the room, hear it immediately and go in? And nobody asked that of Miss Nix, who, as you'll recall, my lady, wasn't even going to be called in the first instance, because nobody had this lost minute case in mind, because it simply hadn't been run. So what we're left with, in my respectful submission, is what Miss Nix said in her witness statement, which we looked at before lunch. It's supplementary bundle, page 61, where she says simply, at around 17:50, I arrived outside the room, I heard what appeared to be a bradycardia, and so I entered. And now we have an attempt, ex post facto, with no evidential basis laid at trial, to say that the judge had to find that she was standing outside in audible range of a CTG for 60 seconds before that. And my simple submission is, no, he did not have to find that.
And you, what do you say? You mentioned this before lunch. What do you say about paragraph 141, which is one of the large number of findings of fact in bold?
What I say, my lord, about that is that the learned judge was summarising the factual evidence on the sequence of events and putting what everybody agreed were approximate timings on various things that had happened. For no purpose at paragraph 141, other than just setting the factual scene. And without any inkling when he was doing so, that the whole case, as I put it, was going to hang on a period of, in reality, a period of between 1 and 119 seconds that separates 1750 from 1751. He had no idea that any of that by saying 1751, she went into the room.
1752.
I'm
1751.
I'm so sorry, my lord. You're quite right.
Yes.
Had no idea that these timings that were just, in my respectful submission, a bit of factual scene setting, were going to be deployed after the event in order to construct yet a new case on factual causation, different from the 4 factual causation cases that had been run up to that point. And so, if one wants to know what he thought about factual causation, and would Miss Nix have got in any sooner, one has to look at the factual causation section of his judgment, where he was directly applying his mind to that question. And it is misleading, and in my respectful submission, unfair to the judge to impugn his factual causation analysis by reference to findings made in paragraph 141, which he would have had no idea had any bearing on his factual causation analysis in the way that's now being suggested. And so the short point in response to my lord's question is those findings do not bear the weight that is now being put upon them. You want to know what the judge thought about factual causation, one has to look at the factual causation section. That's my submission. And turning back, if I may, just to complete the submission about the evidence and why he was not compelled to find what my learned friend says he was compelled to find. I've dealt with the notes. I dealt with Miss Nix's written evidence, where she simply says, in effect, I arrived outside the door and then I heard the bradycardia and I went in. In her oral evidence, and I've made this point, but let me just make it very briefly again, no one asked her, what were you doing in the minute before you went in? Where were you? Who were you with? Were you doing anything that might have made it difficult for you to hear? CTG? Were you on the phone? Were you talking to somebody? Where were you standing? Not a single one of those questions was asked of her. My learned friend's questions, just for the note, are at page 188 to 191 of the supplementary bundle and do not touch on this issue at all.
Well, it was put by Miss Gumble that she was outside at 1750, wasn't it? There was no challenge
No.
to that first time, as it were.
No, there was no challenge to that first time, and indeed the 1750 outside the room was the claimant's pleaded case all the way through.
Yes.
It was never put to a no. In fact, you were out there, you were standing outside that door for an extra minute before you went in. Never suggested. And can I just on this point finally, just before leaving this next, just direct my lords, my lady, to paragraph 199 of the judgment, 144. Miss Nix commented that had a CTG been instigated earlier on the labour ward, she couldn't say whether the emergency caesarean section would have occurred earlier.
Terribly sorry. Which
I'm
paragraph?
so sorry, my lord. It's paragraph 199.
Of the judgment.
Sorry, I'm so sorry. Paragraph 99,
Right.
page 144.
Yeah.
Miss Nix commented that had a CTG been instigated earlier on the labour ward, she could not say whether the emergency caesarean section would have occurred earlier, save that a useful trace to diagnose bradycardia would take about 3 minutes, and the decision would have been made after that. So another bit of factual evidence, but a surprising thing for her to say, one might think, if she had been standing outside the room for a minute before she went in, because one might have expected her to say in those circumstances, well, yes, because I'd have gone in a minute earlier. So in my submission, the judge not compelled to find what he's being criticised for not finding on the notes, or on Miss Nix's evidence, or, and the third limb of this submission, on the evidence of the other witnesses either. Now, we had a statement from Dr. Heath, who is supposed to have been with Miss Nix in this crucial period, at page 83 of the supplementary bundle.
Do we finish with the authorities bundle?
I have, my lady. Thank you. So the purpose which I'm taking the court to this small handful of references is to answer the question: was there evidence in the other witnesses' evidence which would compel the judge to reach the conclusion that my learned friend says he was compelled to reach? First of all, we have Dr. Heath at page 83. Now, Dr. Heath, no disrespect to him, but put simply, was all over the place when it came to timings. He thought that the claimant's mother had arrived on the labour ward at 1700, which was about 50 minutes out. So his recollection was hopeless, and he wasn't called, and nobody suggested that he should have been. More important.
Why are we looking at his statement?
Well, because I'm attempting. Sorry, my lord. As I said, I'm attempting to answer the question that I posed for myself, which is there anything in the evidence of the other people who were there which would compel the judge to reach the conclusion that my learned friend says he should have reached?
Yeah.
And the answer that I'm giving myself to my perhaps redundant self question is, well, certainly there was nothing in Dr. Heath's evidence that would have compelled that conclusion. There's clearly nothing in midwife Bond's evidence that would have compelled that conclusion, because she never gave any.
And there was no witness statement.
No witness statement. She wasn't interviewed during the trust investigation, and nobody thought that there was any need to ask her to give evidence at trial, even though on the case that's now being run, she would have been absolutely crucial, because she's somebody who would have been standing next to Miss Nix in the hypothetical lost minute. So there's nothing from her at all. Midwife Reeves wasn't asked about this at all. We have 85 pages of transcript of her evidence at supplementary bundle 101 to 184, and no one asked her a single question about what happened on the labour ward. The only potentially relevant piece of evidence she gave about this at all is at page 53 of the supplementary bundle. Paragraph 20. I was concerned, she says, in relation to the CTG, I was concerned at not being able to distinguish between maternal and fetal heart rate. Was about to ring the call bell when Samantha Bond entered the room, accompanied by a registrar, who I believe was Dr. Ian Heath, the consultant, and the consultant, Miss Nix. I informed them that I was not sure if I was picking up a fetal heart, and Miss Nix asked for the ultrasound scanner while she manually palpated the claimant's mother's pulse. Now, that doesn't take one very much further in either direction, save that, in my submission. It indicates that at least Midwife Reeves didn't perceive Miss Nix to be standing immediately outside the door at the time, because otherwise, rather than ringing the bell, she would have just asked her to come in. But one has to treat midwife Reeves's evidence with considerable caution because the judge found that it was unreliable from top to bottom unless it was confirmed by the contemporaneous notes. And my learned friend encouraged, understandably, that conclusion.
Well, it was in her closing submission that she wasn't a reliable
Yes.
witness unless her evidence was consistent with contemporaneous evidence or corroborated by another witness.
Exactly so, my lady. Which submission the judge accepted. So the answer to the question I posed myself of was there evidence anywhere else in any of the other witnesses that would compel the conclusion that there was a lost minute in paragraph 296, 297 is no. In fact, it goes further. There was no evidence to support a finding of a lost minute.
How long was this trial?
10 days. I think we may have gone a day or two short, but it was down for 2 weeks, and we took most of it, if not all of it.
The 3rd to the 10th of October, it says on the sounds.
8 days.
Yeah, thank you, my lord. Yeah, 8 days. So, my lords, my lady, those are my 4 key submissions on the main issue of whether or not the judge was compelled to reach the conclusion that my learned friend says he was compelled to reach, and whether he made a Henderson-Foxworth error in 296, 297. Can I, unless I can be of any further assistance on that issue, turn to the material contribution every minute counts point?
Well, before you do, am I putting it too simplistically that the judge's findings that we particularly see around 296, 297, your primary case is these are factual findings. He had no need to go near Bolitho, still less Bolam.
Yes, my lady.
These are purely factual findings, and what he did in respect of Miss Nix was interpose Miss Nix because, as a matter of fact, that was happening at around that time on that Labour ward. Is that it in essence?
That is it in essence. And he was entitled to do all of that, and there was nothing in the evidence to require him to find anything else. That is it.
On a separate point, at some stage you might be going to be dealing with the pleaded case argument, which you put. I don't know whether that point has already been made or whether you're about to make it at some stage.
Well, my lord, can I make it briefly, and by reference paragraph 13 of my skeleton argument,
Thank you.
where I attempt to set out what it is I seek to derive from the fact that, as I understand it, uncontroversially, the case that is now being advanced before this court was not pleaded. I emphasise, as I hope I made clear in writing, but I repeat, I am not seeking to dispose of this appeal on some technical pleading. We understand what is at stake in this case, and it has never been our position that the appeal should fail simply because of a technical defect in the pleadings. The relevance of the fact that in my submission the case that is now being advanced before the court was not pleaded is twofold. Firstly, it would be wrong in principle in my submission to impugn the factual findings of a trial judge on the basis that he failed to make factual findings which were never urged upon him in circumstances where they never formed part of the pleaded case. And secondly, the fact that this case was not pleaded explains what would otherwise appear to be significant deficiencies in the factual evidence.
We've got these points. It's unfair to the judge, and it would have been different evidence.
Yeah.
But what are you going to say about Ms. Gumbel's reliance on 5.6 of the?
Well, my lord, my submission on 5.6 is firstly that 5.6 has to be read as a whole. And 5.6 goes on after the initial sentence to set out what that means on the claimant's case. And the upshot of what it means on the claimant's case is delivery 7 minutes early.
So the argument is that Miss Gumble is skillfully putting together pieces of the information that were before the court to make a different picture to the one that those pieces were being used for.
Yes, my lord,
before the
because
judge.
because whilst I accept that read in isolation, the first sentence of 5.6 is capable of being read as a pleading on medical causation, that any saving of time at all is sufficient to amount to a material contribution. Except that if one looks at that sentence in isolation and deals solely with medical causation. But to get to medical causation, you have to have a pleaded case on breach of duty and factual causation. You have to explain so that the judge and the other parties understand how it is you get to your medical causation case. And what is now being alleged by the claimant is that we get to 5.6 on medical causation by way of an allegation that but for the defendant's negligence, Ms. Nix would have intervened 1 minute earlier. And that was never pleaded.
Well, I'm following that point, but I mean, for what it's worth, this comes under the section of the claim form that is headed factual causation. It's followed by a section entitled medical causation, but this is in fact under the factual allegations that were being put forward. And as you say, read in isolation and at face value, it's that any perceptible delay is causative.
Yes. And my lord, my submission is the only way that that is capable of being an adequate pleading is if it is sufficient in a case of this nature. And this is a conservatively 8-figure clinical negligence claim litigated over 5 years. The only way that is an adequate pleading is if it is open to a claimant in a case of this nature to say, we don't know why or how delivery could have been achieved any earlier. We'll see once all the evidence has been given, and then we'll work out where that leaves us. But if we're able at the end of the process to show that any time at all could or should have been saved, we win. Now, if that is an adequate way to plead a claim of this sort, then I accept that the first sentence of paragraph 5.6 might just be regarded as good enough. But in my submission, that is not and never could be an adequate way to plead a claim like this. You have to identify the breach of duty you allege. You have to say what would have happened as a matter of fact but for that breach of duty. And then you have to show how in those circumstances the injury would have been avoided or lessened. And stage 1 and 2 were just missing here and have been missing until this morning. Because it's only this morning that we get the case that but for the defendant's negligence, Miss Nix would have gained a minute and we would have won.
Well, it's true, but I mean, you're describing what in the old days might have been called an embarrassing pleading, because you didn't know exactly what case you were meeting, so you interrogated it, and we have at 103H the answer to that interrogation, which after something of a run-up says, all delay in delivery therefore made a material contribution, etc. But medical science can't explain how much.
Which suffers from the same deficiency, my lord. Because again, unless it's enough to say all delay made a difference, and we'll get back to you at the end of the case as to how we say that it was a delay.
Why is that inadequate? I mean, you're only talking about a range of times, and everybody's capable of addressing you know, what if 5 minutes, what if 10 minutes, what if 15 minutes, and so on. This was what was going on.
Well, my lord, for, at least in part for one of the reasons that I've already given, which is that if we'd known that the case was being put on the basis of the lost minute between 1750 and 1751, there are at least 3 other witnesses we would have called. There are a whole range of questions we would have asked Miss Nix.
Well, you're now going on, but we
I'm so
severally
sorry,
interrupted you to you are now going on to, as it were, the consequence if you're wrong about that, and the lost minute
Yes.
stands up
Yes.
as an argument for the appellant.
Yes.
What the consequence might be.
Would it be convenient if I dealt with that now?
Certainly would. Thank you.
Thank you. So, my lord, my lords, my lady, in my submission, the consequence, if I'm wrong about everything I've said, and the court finds that the judge fell into error by not finding that there was a lost minute, then the consequence would have to be that the case is remitted either to this judge or another judge in order to address the issue of what that means in terms of medical causation and functional outcome. Because we would then have a situation in which one had a 1 minute saving of time in the context of a 23 to 24 minute acute profound hypoxic episode. And the critical question would be, what difference did that make in relation to the overall injury? And in particular, the functional outcome for the child. And nobody went anywhere near that question in the course of the trial. Lest it be thought otherwise by virtue of my learned friend's references to the evidence of Professor Mitchell, can I just turn back briefly to the relevant part of the judgment where Professor Mitchell dealt with this issue, which is paragraph 242 at page 164. Now, at paragraph 241, you have the paragraph that my learned friend referred you to, advised that delivery at any time would have reduced the resuscitation time, advised that any delay would have continued the increase in primary injury to the claimant's brain neurons. But then he goes on to say that he would defer to a neurologist for apportionment of functional outcomes, and what that actually means in terms of net result, which would be the critical issue in terms of the value and scale of the claim. Now, Dr. Pike was a paediatric neurologist who provided, it's been called a report, but it is in fact a letter of advice, which you have in the bundle at page 240, supplementary bundle. Now, Dr. Pike was not called, and the defendant did not instruct a paediatric neurologist for the simple reason that up until 2 weeks before the trial, when the first set of amended pleadings landed, up until then, the breach of duty and factual causation case had been delivery by delivery over half an hour earlier, because the bradycardia would have been picked up on the antenatal ward. I mean, we were miles back in terms of the chronology. We never got up to the sort of periods that we ended up talking about at trial. So from the defendant's perspective, and you've seen the defence, the amended defence that my learned friend took you to, this was just not an issue. In any event, when one looks at page 240, what Dr. Pike says, crucially, in the second paragraph under 4.3, is, as stated above, acute profound insults lasting less than 10 minutes may be survived in time. Insults lasting 15 minutes or 20 minutes result in survival with increasingly severe injury. An acute profound insult lasting 25 minutes or more is likely to result in the death of the baby. Well, okay, as far as it goes, perhaps. But we're in the period between 20 and 25 now on the analysis, and we're arguing about the difference between theoretically 24 and 23. And Dr. Pike doesn't say anything about that. He hasn't examined the child, or at least he hadn't for the purposes of this report. And he provides no analysis at all of what functional outcome would have been with that very, very small difference in time.
So what is your submission about this? That if one was to have asked that question in writing of Dr. Pike, saying, we now want to hear from you in relation to
Well,
22 or 23 minutes.
yes, my lord, we would have needed to ask the neonatologists and the neurologists, with both sides having an opportunity
Are
to
you,
call their
are you
own.
saying that Dr. Pike's answer to that could be predicted? Namely, I can't add anything to what I've told you already.
Well, I don't know, my lord.
Right, you're not saying that, that's all right.
I'm not saying that because it would depend, if this issue were live, on where we ended up at the end of the ordinary expert evidence process that one goes through in a case like this. We would instruct our own paediatric neurologist. They would meet, discuss the case, and come up with a joint statement identifying areas of agreement and disagreement on what is now the crucial issue of whether 1 minute would make a difference, and if so, how much difference.
I mean, it wouldn't
So-
be unusual, would it? My apologies. When you're putting, and let's take, the joint meeting of neurological experts, it wouldn't be unusual to give them a number of scenarios and ask them to comment on each,
Yes.
because that's what happens.
Yes, but we didn't, I repeat, my lady, we didn't do that because at the time of deciding what expert evidence was needed to be called in relation to this case, the pleaded case by the claimant was delivery 30 minutes earlier, and everybody accepted that in those circumstances, the injury would have been avoided. So we just never got into it, either during the course of preparation trial. Now, I may have seen, my lady, I objected to some of the amendments that my learned friend sought to make to the pleadings at the start of trial, in part on this basis, and I lost, and I'm not seeking to reopen that debate. But the effect of it is that the yet further iteration of the case with which we're now faced, 1 minute in a 24-minute insult, was not addressed by anybody, and it would have to be addressed by everybody thoroughly, with both neonatology and neurology evidence, if this case were to, if this appeal were to be allowed on the basis it's now put. My lords, my lady, I'm conscious of the intervention by my lady, Lady Justice Davies, and so I wasn't proposing to address you at length on CNZ and why it doesn't help in this case. My essential submission is one gets no assistance from another first instance decision dealt with on completely different expert evidence and completely different
No,
timescales.
we needn't trouble you on that.
I'm grateful. In those circumstances, my lords, my lady, unless I can be of any further assistance, those are my submissions. Thank you.
Thank you, Mr. Sheldon. Yes, any reply, Ms. Campbell?
Please, my lord, just briefly, in terms of the pleaded case being only delivery half an hour earlier, I would say that is not really a proper interpretation of the pleaded case. The only amendments were the bit that was added to 5.6 and some further additions earlier. But the
Yes, you say you had a sequence of possible.
My lord, yes, the case was always, and the further and better particulars or further information application was made right at the start of the pleadings. It was known, what do you say, and the question was, what do you say about the time at which the baby would have had to be delivered to save damage? And we said in that response, every minute counts. So that, to say that that's why Dr. Pike wasn't called doesn't make much sense to me in terms of the pleaded case wasn't that less minutes than 30 minutes would make a difference. And indeed, the defendants had accepted that delivery between 53 and 1800 would have saved all damage, by 1805 would have saved some damage, and after that they weren't prepared to say. So they knew that was an issue and they pleaded to it. So I just don't understand the submission that the only reason there wasn't further evidence about shorter periods than 30 minutes was that that wasn't pleaded. I can see there was, I fully accept we didn't plead that Dr. Nix would have been standing outside the room and gone in 1 minute earlier, but we did plead every minute would have made a difference, and they did know that that was an issue at trial. So I simply don't accept that that's the reason why that everybody knew that how many minutes were saved was going to be an issue on both sides pleading. In terms of the 3 minutes and whether this was a factual, the judge interpreted that as on the facts you would have waited 3 minutes to establish the bradycardia. In my submission, it's clear from page 160 in Court Bundle 1, 208 of the judgment, which my learned friend took my lords and my lady to, that there was a question about the Boland position, because at the start of the question is the following timings would have been reasonable in inverted commas, and that can only sensibly be interpreted as those were the times that a reasonable body of midwives or doctors would have interpreted, would have needed, and you wouldn't be negligent unless you were within those reasonable times. And that, as I understood it, was the purpose of that question. So what the judge had in mind, and the only place from which he could have got the 3 minutes was from his own findings. And what seems to be suggested is that the timings at trial were all approximate. Therefore, we can't now appeal on the basis of actual timings that the judge has found. The reason that we've now got specific timings, and I had always said to the judge, it isn't the actual time, it's the sequence of events that's important. We now don't have to go on a sequence of events because the judge has given us actual timings. And when I made submissions to the judge in closing, and one has those in the supplementary bundle, I was specifically saying it was the sequence, but it was obvious that Miss Nix could have gone in earlier if the CTG had been on earlier. And those submissions are made at page 224, and I think they're parts that my learned friend didn't take the court to. I was at the bottom, page starting at 11, the movable part is actually fixed in getting to the ward. And at that point, I was making the submission, which I've accepted that I can't now make because the judge didn't make findings on it, that actually Miss Nix got to the ward, went in and spoke to the midwife and asked her to come out. And that comes from Miss Reeves' statement. Of course, at that point, I didn't know that the judge was going to find that nothing that Miss Reeves said could be relied on. But Miss Reeves had said that Miss Nix came in the room, asked for Samantha Bond and took her outside. So I was relying on that. And I then said, she hears it and goes straight into the room. She didn't say she waited 2 minutes to see if it really was a bradycardia. She went straight into the room. So I'm making the point to the judge that if one looks at this on what the doctor actually did, one didn't have to have the 3 minute waiting to establish the bradycardia. What we do know is that she was standing outside the room for a period of time before she heard it, and that then it was for the judge to make findings as to what those periods of times were and until we had the precise timings that the judge was relying on, it's very difficult to make the submission on the 1 minute because we're waiting for the judge
You
to make
did,
submission.
I'm just looking at what happens at page 226 and picking it up. So the judge and you are discussing this, and at line 11, it appears that he understood your submission at that stage to be 5 or 6 minutes early.
Well, that was the primary submission, but I did say she would have gone into the room earlier and not waited 3 minutes after she heard it at page 227, lines 14 to 18. And then I also pursue the submission that we know she's on the ward round, that she's outside, and the bradycardia would have been recognised earlier on page 230 between lines 1 and 10. So of course, at this point, I don't know what findings the judge is going to make as to the start time of the bradycardia, or whether he's going to find that she did go to the ward, go into the room and ask for Samantha Bond to come out. But I'm now confined by the judge's actual findings, but I would say it isn't right to turn those on their head by saying they're not actual, that they're all approximate, when those are the times the judge has found, and the sequence is the sequence that the judge has found.
Speaking for myself, it seems to me that the times may have been approximate in the evidence or quite confusing in the evidence. But once the judge has made her findings, they seek to be confusing or approximate unless he calls them approximate.
Indeed, and he doesn't. He's quite specific about them. And to the finding in terms of the 3 minutes is not, we would say, a finding of fact, because there wasn't ever a 3-minute timing in which a midwife waited 3 minutes and then called a doctor. The only place the 3 minutes comes from is what the midwife, what was put to the obstetricians as what would be a reasonable time, and reasonable must, in my submission, be a reference to the Bolam test, and that's where the judge has taken that you would have waited 3 minutes. Because it can't be a finding of fact that the consultant would have taken 3 minutes if she'd heard the bradycardia a minute earlier, because that's the implication of my learned friend's submission, that paragraph 257, it's a finding of fact that it would have been, that she would have gone in at the same time. If one unpicks that, that must be a finding that if she'd heard the bradycardia earlier, instead of going in immediately, she would have waited 3 minutes, because that's, if it is simply a finding of fact, that's what it would involve. There was no basis for finding that the obstetrician would have taken longer to enter the room if she'd heard the bradycardia earlier. And that's why it's relevant to apply Belitho, that you know who's standing there, you know what she did at 1 minute later, and you conclude it can't be any different 1 minute earlier. So to describe it as a finding of fact is avoiding the issue that there was no factual basis for finding that the consultant obstetrician would have taken 3 minutes to go into the room had she heard it a minute earlier. Which is the consequence of reading that as simply a factual finding, rather than saying that what the judge must have meant is that it would have been reasonable to wait 3 minutes to call the obstetrician, because that's what the evidence had been on reasonable timings, rather than the evidence on actual timings. I don't think there's any other point on which I sought to reply. I should have said at the outset that the claimant's father is in court. He's sitting in the public gallery because of the anonymity and the streaming, and the claimant's mother, who is the litigation friend, is watching on the stream, just so the court knows that the family are very much involved.
Of course. thank you to council, those who've supported them in preparing the appeal, and those who have instructed them. We'll want to give this appeal careful thought, and we'll therefore reserve our decision and let you have our written judgments in due course. You'll be familiar, but I say it for those who aren't, that the written judgments can of course be shown to clients for the purpose of taking instructions, but they are confidential until they're formally handed down, which will take place in due course. And please assist us by providing any editorial corrections to the judgment and a draft order reflecting our conclusions. And it won't, of course, be necessary for us to reconvene for that purpose. Thank you again.
All right.